Hello, everyone, and welcome to Age Equity Alliance's Giving Tuesday, our day of sharing insightful content around the issues of age bias, myths, and stereotypes that stand in the way of a truly diverse, inclusive, age equitable organization. Today, I am talking to Mahir Nisar. He is an employment attorney with a Nisar law firm. But before I do his formal introduction, I just first wanted to talk a little bit about Age Equity Alliance. So Age Equity Alliance is a 501c3 nonprofit. We were founded in May of 2020, right in the middle of COVID. And our mission is to create workplace age equity across the age spectrum. So in our work, we work with companies, organizations, communities, government entities to evaluate and address age equity gaps. In addition to training, age equity audits, speaking, and consulting, we are also knowledge partners with AARP, the World Economic Forum, and the Organization for Economic Cooperation and Development in their global collaboration called Living, Learning, and Earning Longer. And that program is focused on all age cultures, building a strong multi-generational work culture. And that fits very nicely with AEA's remit because we are focused on age-related issues across the age spectrum. And it's very important to acknowledge that what we have is this cycle of the development of myths and stereotypes, and we have to break the cycle, and we have to break the cycle across the cycle. So it's really good to be a partner with them in the work that they're doing. So today we're going to be talking about legislation. There is a lot of legislation in Congress right now, and the expert with us today is Mahir Nisar. And he is also, in addition to being a principal at the Nisar Law Firm, he is also a member of the board of directors for Age Equity Alliance. His passion is helping people overcome adversity in life, and their livelihood led him to train himself as a life coach. So he routinely provides life coaching and executive coaching in addition to all of his expertise around law. His vision is to cater to a socially just society in which people are judged by their character and skills rather than the color of their skin, their religious beliefs, their gender, sexual orientation, age, or disability. So we are very, very happy to have Mahir and his expertise as part of Age Equity Alliance. And I look forward to our discussion. Welcome.
Well, thank you for such a remarkable introduction. I think we should just end this conversation now and just take whatever I've got here and leave with it. But thank you. Very kind words.
I think there'd be a lot of disappointed people if we left it at
I'm just kidding.
We've got a lot of stuff, so I have to tell you, Mahir, so here's what I did. When I was trying to prepare for this interview, I went out into congress.gov and I just searched legislation that was related to age. There were like 1,000 things came up. And this is just for the 2021-2022 year. Oh my goodness. So how do you decipher through that? And what I'm hoping we'll learn from you is what's the most pertinent legislation that we should be paying attention to right now?
Yeah, absolutely. So as people may or may not know, obviously age discrimination within the workplace, within various institutions such as your housing, such as your educational institutions are unlawful. Now, it's usually under the ADEA, which is the main law that provides protections, which is called the Age Discrimination in Employment Act, 1967. That law basically provides employees protections against discrimination if they are above the age of 40. So if you're over the age of 40, you have that protection. And so if you are, let's say, below 40, you're not really taken into account with respect to this form of legislation. And there's a lot of local state laws that will provide protections in your specific state, may give you protections if you're over the age of 18 against unfair treatment within the workplace on the basis of your age. Now, I would like to kind of bring your attention to the current laws that are actually being considered within Congress, specifically Protecting Older Workers Against Discrimination Act, right? POWADA. And the reason why POWADA has come in is because in 2009, there was a Supreme Court decision, which was Gross v. FBS Financial Services. And in that decision, the court held that the employee that was bringing an employment discrimination claim on the basis of being demoted, and what their basis was, they felt it was based upon their age. The court held that it wasn't enough to be a motivating factor. It had to be a but-for causation, meaning it had to be the determinative issue. Now, the issue with that is that it's not in line with our other laws, such as our Title VII laws, which are the laws that govern anti-discrimination on the basis of race, religion, your national origin, your disability, your sexual orientation, things of that nature, things that identify who you are as a person. So with age has its own statute that has its own legislative intent, and the Supreme Court read it as such and saying, well, we're not going to be using a standard of proof which the Title VII uses. In Title VII uses this process of saying mixed motive. Mixed motive is the analysis. That mixed motive analysis is, could it have, and the way that I look at it is this, that if your race, for instance, your race is 1% of the motivating factor behind the employer's adverse decision towards you, I think you have a legal claim, okay? Now, with respect to the way the Supreme Court held in 2009's decision with respect to age discrimination, they say it has to be 100%. That's the way I look at it. When I say but for, it's 100%. It cannot be just a motivating factor. It has to be the factor. And that is something that this specific law, Protecting Older Workers Against Discrimination Act, is meant to address. It's bringing into consistency, is bringing into line the current law within, in generally anti-discrimination statutes that exist on a federal level with age discrimination, in that now, if this law does get passed and is signed into law, then we will finally see age discrimination being at the same level as other protected classes with respect to discrimination and other adverse actions on the basis of age. So that this is an important law that I think really needs to get passed. And I think, you mentioned before, Sheila, that there's so many different laws and a lot of bills that are being introduced within Congress that are meant to address ageism, age discrimination, and other forms of unfair treatment on behalf of workers that are existing throughout our country. And it's really, I always bring this up because the more that I've always looked into age discrimination and the way that the courts have looked into it, especially the Supreme Court, is that it doesn't really make much sense to me. That where we have a very elderly group of legislators within Congress, the Senate, it's really odd to me that they haven't really brought out legislation to protect themselves as well as other people. And so, interestingly, this is the one thing that doesn't really make much sense to me. And it tells me a lot more about how much, and I don't want to go into politics, but the corporate influence. And ultimately, we do have to address this because corporate influence and corporate influence in the way the laws are structured has a deep impact on how individuals experience their workplace. And if they're not given a fair shot for who they are, if they're being told that they aren't, that they're expected to be a certain way, or that they're going to be held to a standard that is unfair on the basis of who they are, we're just basically just going off of whatever, I guess, makes money and whatever the corporate ladder and that fiscal system tells us, but that doesn't really explain the reality of people's lives and what they can do. So I think that this specific law that is in contemplation, and hopefully I do think has bilateral support. There obviously are people that are opposing it because they don't want more protections for employees in general. But I do think that this is something that has a lot of positive impact on leveling the playing field for those that fall in a protected class and being over the age of 40. So that's the one law. And now we also have an amendment, essentially a clarification that adds on to that, which is the Protect Older Job Applicants Act of 2021, POJA. And essentially, that deals with addressing the ADAA's situation involving disparate impact discrimination claims. Now, when it comes to disparate impact versus disparate treatment, just understand the difference. Disparate impact is the concept where there are certain policies that an employer has, and they look facially neutral, meaning that they don't look like they're discriminating against anyone. But the impact of the way that that policy goes into effect and how it plays out is that certain groups of people feel the negative impact of it, that they're harmed by it. And when it comes to facially neutral, policies that exist by employers that are using certain language that may not on its face look like it is targeting a specific protected class, it ultimately excludes that protected class. And so this language is meant to address, this law is meant to address making sure that this protection is added on. So we cut off this idea that disparate impact claims for applicants, and especially I think this really came about as a result of what we saw, like I think on Facebook and a lot of these other third-party social websites that were putting up job applications, and they were being shown to certain people. And so while it may be facially neutral, the impact was that they were actually discriminating against people that were older workers over the age of 40. So this is a new law that will provide clarification and add in specifically for disparate impact claims that external job applicants will be a part of a protected group of people with respect to that law under the ADEA. So these laws, essentially, these specific laws they're building and amending and clarifying the existing law under the ADEA. So that's pretty much within the context of what we have to look out for. I think that these two forms of legislation have a good possibility of moving forward, and I do think that they'll have a good impact on our overall work culture, and obviously will make employers really look into how they are structuring their policies, as well as how they are conducting their hiring decisions and how they are conducting ultimately any employment decision as a part of the process.
So I have a couple of questions I'd like to kind of dig into, and I invite anybody on the call for any questions you might have, drop them into the chat. We want to answer everybody's questions. So one part of what I read around POJA was that it also was going to require the EEOC to investigate complaints of age discrimination in the application process, right? So does that mean that the EEOC then has to do a look back on what's already been done, or do they just start monitoring it moving forward? Because I know a lot of people have made complaints historically and nothing has been done.
Just to make sure that you're aware, so POJA does not address disparate treatment. It deals with disparate impact. So it's essentially looking to make sure that those employers that are out there that have these facially neutral policies with respect to hiring have provided everyone an equal fair shot. And so nobody can be unfairly pushed out in a not necessarily direct way, but an indirect way by way of the policies that have been played out. So the EEOC obviously is what governs and enforces the ADEA. This specific law that is being proposed has the impact, and I think this really comes about as a result of two other decisions that came out in the circuit courts that dealt with especially this, and this is why it came about. A lot of these specific laws are as a result of how litigation has played out, how pursuing claims of age discrimination and disparate impact claims on the basis of age are, how are they going to address it? Because it's not fair. It's not fair that employers are getting away with circumstances in which employees who can show that this is wrong, happened on the basis of my age. Why are we not getting our day in court, and why aren't we getting any form of justice? And so these specific laws are trying to bring things back into a level playing field, so that way you can have that opportunity, because it wasn't clear from the legislative intent and the way that the courts reviewed the legislative intent and the way that the laws were actually written. It was, once again, very employer friendly, very corporate friendly, less protective for the individual. So in terms of a look back period, what you're essentially addressing is whether or not they will look back. I'm not too sure that they're going to look back. It's going to be forward facing. It's going to be towards making sure that facially neutral policies that exist now are going to be compliant with the law once it gets passed. Obviously, this law has to go through a process of being vetted, and then it has to, kind of expand and how it's going to come out and be implemented. And we're still somewhat in the infancy stages of seeing whether or not it's ever going to get passed in the first place. But I do think it's going to be more forward-looking than going back.
So I was kind of thinking about the class action lawsuit against IBM, where after, the top was blown off, and they really were revealed for all of the age discrimination that had been going on under the roof of IBM, how the EEOC actually went back to all these previous age discrimination claims against IBM. They had been dismissed. And then they pulled them all back together, and that became a part of a class action lawsuit. So I just wondered if anything like that was possible, and if that's something that legislators are worried about, because, one senator said it's just going to lead to more lawsuits and whatever. But if people are going through the EEOC, it's not like, they're hiring a private attorney and, taking the company to the cleaners. They're just trying to get justice, right?
Yeah, absolutely. And I think, so I mean, in terms of the IBM cases, and certainly keeping in mind that we kind of identify disparate impact versus disparate treatment claims, and understand that they are two separate things in terms of how an employee experiences discrimination on the basis of their age. Certainly, the EEOC is going to be governed by whatever authority not only Congress gives them in terms of enforcing any of the laws that have been created, but also the new laws that are going to be implemented, and how that's going to either have a look back or whether it's going to be forward facing. I think if they give them the authority to open up all past policies and start to bring class actions and holding them accountable, certainly I think that that's going to open up a lot of potential litigation as well. So I'm not too sure how that's going to go, but I can say that with respect to the legislation that currently exists, I think the one thing that we know, a lot of people that are opposing any form of legislation to provide workers protections, that provide them equity within the workplace, that provide them the protections to make sure that they have a fair shot in being treated fairly, is that they always will say, oh, this is going to cater to more litigation. The idea behind having good laws is that employers are regulated to provide work environments that are going to protect people and that they won't violate their rights. And so if employers are going to comply with the laws as they are currently structured, then we should see less lawsuits, in essence, because the only time that you see more lawsuits is when people are aggrieved, when people have experienced unfairness, have experienced some of injustice. You lose a job and you know it's because of your age or your race. What other option do you have? You have to go to the EEOC, you have to exhaust these administrative processes to be able to use the federal court system to pursue your claim. And so these are the mechanisms that exist in order to seek justice. But the laws, ultimately, the laws that we currently have, are the mechanisms that are meant to protect us, protect people. And if they fail to do it, then people will need to raise their voice and pursue whatever exists within the law. So I think that these laws have the potential of actually, in many ways, catering to better workplaces, better work environments, making sure that employers are going to be more compliant with what is right, and making sure that their cultures reflect that. And that, in essence, I think is going to reduce lawsuits, if anything, because I think that they will be more careful about not engaging in discrimination, because that's not what they should be doing in the first place.
Right.
So I think that I think is definitely going to be what I see in the future. But I'm hopeful. I mean, who knows?
Yeah, one can only hope.
Yeah.
I think that what a lot of people are asking and wondering, Mahir, is this whole idea of code language that is used sometimes in the hiring process. You know, this overqualified is just kind of code language for you're too old. So is that impact or is that treatment? I'm not sure.
So that's a great question. So it depends on if it's a matter of impact, right? If we're talking about disparate impact, then we're looking at a specific policy. And let's just, for this purpose, let's talk about job applications. Let's say that there's a posting of a job, right? That specific job description is going to tell us a lot about what they're looking for. Who are they looking for? And if that language, facially neutral, right, doesn't say anything about your age, right, but the language kind of limits the time frame of the amount of experience that you have, perhaps says something about want somebody who's very, very fast. I don't know. I'm just giving examples, like scenarios where they're trying to identify people in a certain stereotypical way as to what they want to actually hire. That gives us a little bit of the imagery of what they are targeting and who they are looking to exclude. And so people that will look at that application, they'll look at it and they'll look at, okay, they want this, they want this, they want this. Okay, I'll apply for this job, but they won't be considered because of the fact that they don't really fall within that specific, I guess, whatever they're actually looking for. And so that's the idea, is that people are on a facially neutral job description are being denied opportunity on the basis of who they are, based upon certain stereotypes, based upon certain generalizations, that if you are older, you are slower. If you are older, you are incapable of actually using technology in the manner in which that specific employer would like you to, that you're not up to terms with using other forms of third-party applications, or you don't type as fast, or whatever the stereotypes may be, right? Because there's so many of them, and employers and people that are working within the work environment will use language, coded language, like you said, that will be meant to make the person feel that they are inadequate. And when you really boil it down, it comes down to who they are as a person and what their age is. Because as they grow older, as they are aging in a general way, people will look at them, not because of what they do, but because what they perceive within them about how they are going to do what they're going to do. They don't even give them the opportunity. They already make assumptions. And that's the biggest challenge that we have within, this all comes down to why I started to go into coaching, because it's so important from the perspective of leadership development, so important from the perspective of communication development, that the one thing that I think leads to so many problems is this idea that we can assume things about people based upon what we have been explained or told, or what we have read through mainstream culture, what we have seen in pharmaceutical ads, what we have seen in mainstream movies about people that are older, right? When they're older, when they're 40, 50, 60 years old, that what are the underlying assumptions and what we have been told that we should have this imagery within our mind. When we think of somebody who's in their 70s or 80s, do we think of them? How do we think of them? What is the first image that comes into your mind? What is the underlying bias that has been nurtured as a result of all the information that you have been fed? Those are things that I think give us that disparate impact type of a model where they're trying, whoever's creating those applications, whoever's creating those descriptions are doing it with the intent to exclude certain populations.
Deliberate intent.
Yeah.
So let's go back to POWADA and POJA. This is what has always disturbed me a lot in the research that I've done around Title VII and the ADEA. I don't understand how the circuit's courts could justify divergence in the way they treated the Title VII protections and the way they treated the ADEA protections. Can you help me get my head around that?
Yeah, it's a tough one. I think from the way that I understand it, and a lot of times we are meant to understand things that don't make sense, and they don't make sense to us because when we look at the way decisions are made, right? A lot of times the decisions, the way that they're rendered are based upon, sometimes they look at the legislative intent, they look at how the law was intended to be, why it was intended to be this way, and what is the burden of proof? How is the process for anyone to seek any kind of remedy through that legislation and that law that protects that individual? So with Title VII, we talk about how Title VII did not contemplate age. It talked about race, religion, national origin, and other aspects, right? So it's a completely separate law from the Law of Age Discrimination and Employment Act, the ADEA. And the ADEA has a different legislative intent. I mean, ultimately looking to protect people on the basis of their age from unfair treatment. And it's very clear as far as that goes. But the idea is that there are certain aspects of it that have been interpreted in different ways. And Title VII has a lot of case law, a lot of case precedent that have come about in terms of how to prove unfair treatment, disparate treatment, whether it's disparate impact, and how you're going to go about proving it and how the court's going to look at it. What is the burden of proof going to be? What are the things that you need to show in order to be able to prevail under the law, to show that your employer actually unfairly treated you on the basis of who you are under those protected classes under Title VII. Now, from what I've seen in other courts, a lot of courts have borrowed the Title VII mechanism of mixed motive analysis, of saying that if it's a factor, if your age is a factor, then that is what makes it illegal. Whereas in 2009, with the Supreme Court ruling, they went back and said, no, that was all wrong. We should only be focusing on the way that the legislative intent was, because the legislative intent was, according to the way that the Supreme Court reviewed it, is that they didn't talk about it being a motivating factor. It became more of a causation issue, being that it's a but-for causation. Now, I had a discussion with one of my partners, and can't really figure out the difference between a motivating factor versus a but-for causation, because in essence, aren't they both motivating factors ultimately? Isn't it the same thing? Well, I tend to agree with him. However, the way that the courts look at it and the way that I've come to understand it is that I look at it from the perspective that when it's a motivating factor, anything above 1%, right? Mm-hmm. If it has anything to do with it, you got a claim that you can pursue. But with but-for causation, you're saying that it's 100%. That's the way that I see it. I see it 100% that it's the only reason why you're experiencing adverse employment consequences on the basis of your age. And so the standard is so high. It's so high. It's so high to be able to prove it. And this is one of the reasons why we've had this discussion before as well, is that it's the hardest claim to succeed in. And so these specific laws are meant to level the playing field for people that are experiencing these unfair treatment and be able to actually be able to seek remedies and be able to get better compensation, better damage recovery. And I think that once that happens, once employers are aware that their overall liability is enhanced, it's increased by way of how this law levels the playing field, they're going to have to change, because they don't want that. I don't get the sense that they want more lawsuits.
Right,
So,
right.
yeah.
They want to, they don't want to, they want to eliminate litigation risk, obviously.
Yeah, I think they do. I think that I think the way that businesses, and this is just as an employment attorney, I think the way that I view it is that with how do businesses, what is the focus of a business? And most MBA people that go through these different mechanisms of building businesses, they focus on making profit. It's about making money, right? And ultimately, what is going to make them the most money, and what is also going to limit the most amount of exposure to losing that money, I think really drives a lot of their decisions. And I think that that's something that, as a overall culture, as an overall society, is extremely harmful, because when we prioritize money as the sole motivating factor behind the decisions that we make, we eliminate a sense of civility, a sense of human dignity, a sense of doing the right thing that I think that we as a society have lost as a result of this corporate desire to consistently gain more and more and more. And this is an effort to try to level that playing field, to get people to have the necessary rights that they need to have in order to finally get, some form of justice, because it's just not right. And I think that when we just talk about things from a perspective of what's right and wrong, I think a lot of people have a lot of gray area in that, and it's very unclear.
Right.
So,
Well, long overdue, and I crossing my fingers and writing my senators and all that good stuff. We do have a question that's come in.
Sure.
So the question is from Jennifer, and she says, my employer seems to have a lot of discretion to interpret EEOC processes and law that stacks the deck against the employee claimant. Is this typical? Is this typically the case? Will pending legislation address it? Thank you, Jennifer.
Yeah, Jennifer. So, your employer definitely has a lot of discretion in how they implement any kind of policies within their company, as long as those policies do not run afoul to the laws that exist within federal law, which apply to every state throughout this country, as well as your local state laws and city laws. So as long as those policies that are implemented are non-discriminatory in nature, and do not have a discriminatory impact on somebody or a protected class, they will be considered legitimate business policies. I think, a lot of what we're seeing right now, at least what I'm seeing right now, is a lot of conversation about employer mandates. And so I won't go into that discussion, but I'll just say it from the perspective that a lot of people are very unhappy with the idea that an employer can tell people what to do, and how they should live, and how their employment is tied to whether or not you comply. So I think there is a lot of concern on that angle, but the EEOC looks at it from the perspective of a larger federal, state-based, country-based, national motivation in making sure that they are compliant with the local, federal, and state laws. So I think from the perspective that I think that as long as you're able to show that the policies and what's implemented is neutral and is fair from the perspective of not being discriminatory, I think that the EEOC is going to be more deferential. They're going to show deference to that employer, and employers are fully aware of that to make sure that they are compliant and that they are going to be able to do whatever they want to do, but not be held liable for anything that you may feel is unfair.
Awesome. So I'm going to shift gears a little bit. And so POWADA and POJA, that's legislation that's geared more toward the older workers. But I did see several pieces of legislation floating around out there that actually are geared to help younger workers build skills and enter the workplace. Is this anything new, or is this just tweaks to existing programs?
So I think some of these programs that you're mentioning are talking about, like the Creating Pathways for Youth Employment Act.
Mhm.
I mean,
Youth
this
Corps.
specific,
Mhm.
right, this specific legislation is really meant to provide funding to various state-based and non-governmental organizations that will essentially provide children over the age of 14 to the age of 24 certain subsidized opportunities for employment within their specific states. And I think it's targeting specifically those places in which there has been some economic distress areas and some form of criminal injustice. And so these methods are really meant to encourage, to give opportunities to those that have been disadvantaged by overall society in general. So I think that this is, positive that they're looking to try to address this. But I do think that, we talk about this before as well, and we talk about how various states have different laws that provide you broader protections, especially if you're over the age of 18. So you could probably check wherever you're watching this from. If you happen to be in a state such as New York or New Jersey, your laws will protect you against discrimination on the basis of your age if you are over the age of 18. And ageism and Age Equity Alliance is meant to make sure that we address these issues across the spectrum. It's just not ageism from the perspective of those that are over the age of 40, 50, or 60, but it also applies to people that experience unfair treatment on the basis of certain age-based assumptions and stereotypes that exist at a younger age. So people might be held to standards that are unfair and illegal. So looking at your local state laws is very important to make sure that you know what protections you have and how you need to go about addressing them.
So here's a wild question.
Yeah.
Way out there. So in I guess it was 2007 or 8, the UK began pulling all of their different protective legislation under one bill, the Age Equity Act. And so now everything is under one bill or one piece of legislation. And with age, they don't have any defining, number of years at which age protections would begin. So it's kind of inclusive. But so my question is the wild question. And I've asked other attorneys this too. So I'm looking forward to hearing what you're going to say. Do you ever foresee a time when the US would bring all of their protective legislation under one piece, one legislation?
Specifically to age?
No, like all the protections, race, gender, age, anything we have legislation around under one equity legislation.
I mean, it's a hopeful thing, right? If you're asking me from the perspective of what I hope for, I certainly think that I think that the way that the system is currently structured is we have so many layers to this system that is catering to what we see today and how people that are from marginalized communities, and all of us will hopefully, and I repeat this, hopefully will be able to get older, right? Not everybody has the privilege of getting to an older age. So I think that it's a good concept, but I think that as long as any legislation that is brought about addresses the experiences of those individuals that experience a certain form of discrimination and those common fact patterns that exist in terms of the experiences that the system caters to, if it does cover it, I think, yes, it makes sense that there's new legislation that is going to be able to give much more protections to people. And ultimately, I think that this country, obviously based upon capitalism and based upon a lot of the deregulation that we've seen throughout the years, is in many ways, I feel, and this is just a personal opinion, I feel like it's somewhat structured in a manner where people are not the priority. And I look at this this country that has a very unique index, which is called the gross domestic, I think it's the gross domestic happiness index, I believe, in Bhutan. And so it tells me that we're not really focused on happiness. We're really focused on more productivity, more GDP, things that I think that overall for people that live within this country are meant to face a lot of they're meant to face a lot of mental health impact and psychological illnesses as a result of what they're going through. So if we're going to change our society, if we're going to change the environment that we're kind of catering to in terms of our politicians and our legislators and how our system is currently operating, yes, I do think that it would be advantageous that if the system changes, in that our focus is towards making a better society where people have that there is a lot more of an acceptance and belonging and diversity and inclusiveness throughout. I think that legislation should reflect that and only meant to protect that. But I think ultimately these are very culturally sensitive things that need to be somewhat a part of our educational systems, have to be a part of our communities. And I think that, with Age Equity Alliance and all the work that, even I believe that I'm doing, I feel that the workplace is one of the places where there is a possibility that we might be able to change society, because how you interact with people that you are forced to interact with because you happen to be within a work environment from different spectrum, from different backgrounds, you're ultimately catering to how you experience somebody else and how you will go out into society and share that experience with others. And ultimately that caters to your society and your community. So to answer your question in a long-winded way, just giving you the context of my thought process, I think that we would be better off by having better legislation that would contemplate a more robust protection of all people from all intersectional identities, to be able to kind of put together more protections for people across spectrums, so that way we can kind of provide people an opportunity to be more happy within this country and to feel included and to feel accepted and to feel like they belong. If they don't feel like they belong, then it's an extremely difficult thing to experience.
Yeah, it would be, I think it would be wonderful for the people to feel like they came first. Geez, I don't know. I might need my rose-colored glasses for that one, to be honest.
Yeah,
So,
I think, yeah. I mean, yeah.
Go ahead. No, go ahead.
No, I just think that, we have a system. I think this country has this country has a lot of beautiful things to it. I feel a lot of amazing things. I just have to get our priorities straight. I think
Right.
that's where we're somewhat lacking. I think we're too polarized. We're too much fighting or too much disagreements on things that are important but not really urgent. And I know that there are many more urgent things that I think need to be tackled that are catering to a long-term impact on our communities overall that are just being ignored. And I think that the more that we start to advocate for things that are meant to cater to equality and opportunity, when we cater to more equity within our communities, when we feel like we're catering to that, I think that we overall will see the benefits of that to our overall communities, our society, our children. And I think that makes a huge difference in where this country can go. But until we are able to make sure that employers and institutions that have routinely cater to some semblance of discrimination are held accountable by laws that will actually cater to them, believing that it's better for them not to do it, to punish them, to incentivize them, to make it better, I think that we'll have a better society to look forward to. I think right now we are it's the opposite. Right now it's like we have a lot of obligation to be able to prove things that are very difficult to prove in order to be able to hold employers accountable when employers have the strength and the power dynamic to be able to develop the records, develop the legal thing, and have the lawyers and the money and every single thing to protect themselves, what people feel defeated. And more people over time feeling defeated in that way, feeling like they're not accepted for who they are, rejected. These are not feelings that any culture or any environment should cater to.
So I know we're at time, Mahir.
Yeah.
I would just love to just squeeze in one last little question. So, you know, we're talking about accountability and how it can incentivize organizations to do the right thing. And so I'm thinking about the EEOC one, you know, reporting that they do around race and gender. Would that help to add additional reporting mechanisms? Do you think that's helpful, or is that just a pain in the butt and doesn't really matter?
It's a good question, and obviously a very sensitive one, because I don't know where this is going to go, but I'll say this. I say that I think our institutions need to have a sense of independence to focus on what they need to do in order to cater to more accountability to those companies that have routinely and historically engaged in unfair treatment of people that come from marginalized backgrounds. I think that the EEOC has an important role. I think they're underfunded, and I think that it's sometimes a roadmap to seeking pursuit in court, rather than a forum where resolution is actually possible. There has been a lot of change as a result of this pandemic, that the EEOC has become more of an opportunity for mediations to occur, where we can have alternative dispute resolutions to address these things. But ultimately, the EEOC is an enforcement agency, right? And so this agency is limited to enforce what the laws are. And if we don't actually cater to laws that are going to be much more protective to the degree that the employee has at least an equal bargaining position with an employer, I always feel like we're always at a disadvantage. And this is coming from somebody who represents employees. Right. So we can use the system, we can navigate the laws as they currently exist, and we can advocate zealously for our clients in the way that it is currently structured in this system that has been historically in favor of employers and institutions. And the EEOC is one, stepping stone for a process. But ultimately, when it comes down to it, we have to change our laws, and we have to change the systems in the way that they are currently being enforced and what they're actually leading up to. So I think it's a multi-layered approach, but better laws do cater to better results and better accountability, and ultimately better employers, and employers ultimately start to change things because they want to make sure that they're compliant. So I think that there's a lot of work to be done, and I think these new laws that we talked about today are a step in the right direction. And I'm hopeful that with the passage of these laws and other laws that are meant to address, employment discrimination, that we'll be able to kind of cater to really the goal, which is equality and opportunity and equity across the board.
Absolutely, that makes perfect sense to me. I get that. So Age Equity Alliance, this has been our day, our Giving Tuesday, our day of giving back to the communities that have so graciously supported us. So while we've been talking about legislation, what Age Equity Alliance is all about is getting into the organization and helping the organizations create these inclusive workplaces, helping them understand the way bias shows up in language and behaviors in ways that they don't even realize it. I try to give companies the benefit of the doubt, and that a lot of what happens in the workplace is not conscious, it's not deliberate, it's not divisive, it's just out of ignorance, and they just don't understand the way age bias and myths and stereotypes can create exclusion across the age spectrum. So I love my work. I am so glad that Age Equity Alliance has you on the board and that we can benefit from your expertise. I want to thank everyone who's joined us today. Thank you so much. And wishing each and every one of you a happy Giving Tuesday. Encourage you to visit our website, ageequityalliance.org. Would love for you to join our newsletter. And if you feel so motivated to become one of our supporters. Anything else you'd like to share before we say goodbye?
I want to thank you. I want to thank Age Equity Alliance for giving me the opportunity to speak to everyone here today and to address this very important discussion about things that will hopefully cater to more equity within our society and hold employers and institutions accountable. I think that, I talk a lot about things that are in many ways meant to make people feel like that the cards are stacked up against us. But I'll say this in parting, that I am very hopeful. I think that there is always a way. There's always a process that can be utilized in order for you or anyone that you know to seek justice when you feel like you have been denied it. It's just a matter of looking at the context and seeing what you can do in the context of what the laws are. But I do think that at least from what we're seeing movements, we're seeing a lot of social activism. Just stay positive and continue to be an advocate for yourself and for others. That's what I'll leave with. So thank you.
Well, thank you so much. All right, everybody. Appreciate you being here, Mahir. Thank you so much.
Thank you, Sheila.
And take care, everyone, and good night.
Take care. Take care now.